Congratulations to making it to the third and final unit of How to Think Like a Lawyer. You've now done your midterm, you've done your first two tests, and we're proceeding to the last unit. This unit for this module, which is Module 9, Week 11, is on facts and the distinction between questions of law and questions of fact. This is not without difficulty. This module takes up the question of questions of facts and examines the reasoning process that legal decision makers use to determine, in the first instance, simply what happened. So we're looking at Frederick Schauer's Is There a Psychology of Judging? And also Stephen Warner's The Civil Jury and the Law of Fact Distinction. Our book chapter this week is Chapter 10, which moves into a new section, Part 3, which is Why is the Law So Either Or? So I want to start first with the article that is on the psychology. Is There a Psychology of Judging? By Frederick Schauer. So let's look at his article. He talks in this article about the cognitive processes and biases that shape how judges make decisions. And he does this in the context of distinguishing between laws and facts. He emphasizes that judicial decision-making is not merely a mechanical application of rules to facts, but rather involves complex reasoning shaped by psychological factors. And his work suggests that while judges may strive to adhere to legal standards, their factual assessments, interpretations, and conclusions are influenced by cognitive limitations and contextual factors. He starts his article looking on page 1 at looking at what all judges have in common. Number 1, they're judges, in some cases magistrates who are appointed as well. They're lawyers, typically, and they are human beings. And then he talks in his article, he doesn't come to a conclusion, but he asks a number of questions about this. He looks at more often implicitly rather than explicitly. The existing research tends to support the view that judges' attributes as human beings reveal more about the psychology of judging than does anything a judge might have learned in law school, acquired in the practice of law, or internalized by virtue of serving in a judicial role. He talks further about the existing research tends to slight the areas of judging that are different, such as selecting the relevant law, interpreting the law, sometimes making law, that are more or less exclusively the province of a judge. This is on page 4 of the article. And that it might be a mistake to draw conclusions about how judges reason with rules and precedents and authorities from the way, separate and apart from the way in which a reasonable man or a Clapman omnibus deals with similar inputs into and constraints into his decision-making process. Some of the other points that he makes here when he's talking about the distinction between judges, their psychology and their reasoning versus other human beings. He looks at some issues on page 9 on what is legal thinking, what is it that distinguishes judges from other human beings, and talks about legal thinking is the ability to seek and do justice in individual cases. It's the capacity for self-critically seeing and appreciating viewpoints from opposing points of view. It's about the tendency towards clarity and analytical precision, a talent for understanding and dealing with facts, the facility for argument and debate, and the capacity of engaging in analogical reasoning. A lot of those are things that we've talked about in earlier sections. But one of the things that he then differentiates for judges alone is second-order reasoning. And he starts that discussion on page 10 and defines that as the best legal rules may be one which produce an unjust result in the present case, but which may produce better results in a large number of cases, the result in the present case notwithstanding. And I would tell you that that's something when you're filing a brief in the appellate court, particularly less in the trial court, but sometimes in the trial court, that part of your argument might be, well, what's the precedent you're setting here? If we do this in this case, what happens in the subsequent cases? And so it's not just constrained when you're either reasoning as an attorney or when the judges are looking at that, it's not just constrained to that specific case, but you're looking at what is the overall implication of this decision that is being made here and the factors that weigh into it. I spent 10 years on the bench as a magistrate, and I know that I was looking at those fact patterns in that specific case, and it was very subjective in family law, custody, divorces, dissolutions, those type of cases, but also looking at the overall picture. So an example of that would be, I would have heard all of the stalking and domestic violence protection order cases in the small Ohio county where I sat on a bench. Sometimes people would file a motion to modify it later. And so I went to the judge I worked for and I said, I don't believe we as a policy should ever accept a written motion signed by a pro se person particularly, but even if there's an attorney, without doing a hearing, because we can't tell in a domestic violence or stalking situation what the scenario was where they filled out the form, because in Ohio, stalking protection orders and domestic violence protection orders all have forms available on the Ohio Supreme Court website, and there was no way for us to know whether the person was coerced. So our policy became that if someone wanted a modification or a change in those protection orders, they needed to come into court and under oath acknowledge that they were seeking this change and that there was a reason for it, so that we knew that it was not coerced and that we had a record to do that. So that started with one application to have a change in writing, and then my view was, let's look at the overall court policy. What are we doing? What's the precedent we're setting? So I think that's a reasonable thing that he is looking at in his argument about the fact that you need to look at that secondary level when you're making decisions or making arguments as an attorney. So that's set forth in his Shower's Psychology of Judging. His writing does explore the cognitive processes and biases that shape how judges make decisions, and he does it in the context of distinguishing between laws and facts. Shower emphasized that judicial decision-making is not merely a mechanical application of rules to facts, but rather involves complex reasoning shaped by psychological factors. And his work suggests that judges may strive to adhere to legal standards. Their factual assessments, interpretations, and conclusions are influenced by cognitive limitations and contextual factors. So I think we talked about that as well. This then ties together with the Stephen Warner article about the civil jury and the law-fact distinction. Warner, in his analysis of the civil jury's role and law-fact distinction, focuses on how the division of labor is between judges and jury and creates a challenge in distinguishing what is, in fact, a question of law and what is a question of fact. So we're looking at his article and the distinction between questions of law and questions of fact. This is one of the most fundamental questions in legal reasoning and adjudication, because questions of law involve the application, interpretation, or validity of legal principles, statutes, or rules. Courts and judges often determine these questions because they require legal interpretation. By contrast, questions of fact revolve around what actually happened in any given situation and are typically decided by the trier of fact, which can be a judge, but it can also be the jury that's acting as the finder of fact. And in the practice of legal decision makers they often grapple with separating the two domains, as many issues presented are both have factual and legal dimensions. When Werner's looking at different things in his article sets forth that the determination of whether a party has acted as a reasonable, prudent man would act under similar circumstances is a question of fact for the jury. He discusses this in section 2 on negligent cases about what is the reasonable man standard. That's the quote I just gave you is from page 1877. On 1882, his position is if a judge feels that the answer is obvious, that he's going to direct a verdict. So the question of fact is for the jury unless it's so open and obvious that the judge has to do a directed verdict in the case. Werner talks a lot and puts a lot of emphasis on the fact that both federal and state constitutions preserve the right to trial by jury, and that the jury is the one that is supposed to decide the facts. he looks at this in a number of different situations. As I said, in section Roman numeral 2, negligent cases, his argument is that it's a jury that should be determining what a reasonable man is. He carries that argument forward, looking at it in a number of other cases, commercial cases, when you're looking at the reasonable time within a contract. His position, again, is that that should be a question for the jury. And he in each section talks about how different states do it, how different cases do it, and the constitutional implications of that. Section 4, he's looking at malicious prosecution cases and whether there's reasonable cause to bring that case. Again, all of these have that reasonable standard that his argument, Werner's argument, is that should be under the province of the jury. His last example in section 5 is false imprisonment cases, and those are about whether there's probable cause to arrest or detain a person. And again, kind of that reasonableness standard. His argument throughout is that although courts can differ on these kind of cases, he takes the position in Roman numeral 6 that there should be a fresh approach that is clearly warranted, that the task of law application should be entrusted, he says the right to the jury trial, should be entrusted to the jury because the right to a jury trial in a civil case at common law is a basic and fundamental feature of our system of federal jurisprudence. So he's making the argument throughout here that it is in fact the jury that many times should be the one making the decision. You'll look at the lecture notes on elaborating on questions of law versus fact. There's a number of real life examples there. The first one talks about a contract dispute where a supplier and a buyer enter into a written contract for 100 widgets. The supplier claims they in fact delivered all 100. The buyer is instead asserting that only 80 were delivered. And the contract states that the payment will be due upon full delivery. So the question of fact here is how many widgets were delivered, and the position is this is a question of fact. It relates to determining the actions and events that took place, testimony of evidence and witnesses, and who should be making that determination, the judge or the jury. The question of law is if there are fewer than 100 widgets that were delivered, is the buyer legally obligated to make any payment under the contract terms? This requires an interpretation, a legal interpretation of the contract. So that gives a model answer here that factually the trier of fact would assess delivery evidence such as records, receipts, testimony of witnesses, and legally the court would interpret whether there was full delivery, whether that is a condition precedent to payment of any type, or whether partial performance is, or a prorated payment is applicable in this case. And that's going to tie into what we're looking at in the book, where it's looking at a continuum, whether the law has to be black and white or whether there's a continuum of solutions to legal questions. The lecture notes on Werner are page 2 of the section that talks about readings on facts. And we also talked about the Schauer's psychology of judging as well. And it does give you a couple of applying, the third page talks about, of those lecture notes, applying these theories in the law-fact distinction, and that Schauer and Werner illustrate that decision makers in the legal system operate under blended cognitive, psychological, and institutional influences. That means that even clear-cut distinctions between law and fact sometimes become blurred in practice, as judges' factual assessments may be swayed by their understanding of the legal implications, and jurors may unconsciously apply legal reasoning. So that the jury might step into that role of determining law, and the judge might step into that role of fact-finding, even in a jury trial. Obviously, a trial to the judge is asked to do both of those, to be the trier of fact and also the one that's deciding the law in that case. So those are what those articles are talking about this week when we're looking at questions of fact and questions of law. We start the new unit, part 3, on why is a law so either or in the book. Chapter 10 is the proverbial rigidity of law. So it's really asking why should things be black and white? And it starts with this example of a 1980s case, an attempted murder case, and there's a young woman named Hildy and a man we're going to call him Bruno in the book. Basically, they start this relationship, and he then preys upon her gullibility. He asks her to pay money to this monastery so that this person can help her go to the next level of life, essentially. And so she pays 30,000 Deutschmarks or $15,000 for this. After she pays it, he kind of then ups the ante and tells her that she needs to leave her old body behind, and so she needs to get an insurance policy for 250 Deutschmarks and name him as the beneficiary, and then stage an accident. And so then he keeps giving her, Bruno keeps giving Hildy these scenarios to go in front of a moving car and some other scenarios, and she continues to live through all of these. And she then discloses this to someone, and Bruno becomes arrested and charged with attempted murder. But the problem of the case is that all of the deadly activities, all of the proactive actions to cause death were actually carried out by Hildy herself. So it starts asking the question about giving scenarios like you hand somebody poisoned water, the person drinks it themselves, but your intent was to kill them, that would be murder. So kind of this question on, is it murder? Is it not murder? Is it a person choosing voluntarily to commit suicide? Is it murder? Like, where is the line? And so it asks on page 142 of the book, why do we have to pretend that it is like either of these cases when it's really neither or both? Why not acknowledge that it's a hard case because it's partly like a murder case and partly like a suicide case, and that the resolution of the case lies somewhere between these two extremes? So this whole chapter is looking at, why does it need to be either or? Is there some middle position that the law can take? And if the law can, then why aren't we looking at that? In fact, it asks that question straight up on page 143. Why is it that the law does not just split the difference? Since batteriness is a matter of degrees, let the remedy for it also be a matter of degrees, and then cut the sentence or the damage award in half when you're somewhere in between this. So that's what this whole section, this last unit of the book is going to be about, is why the law is so either or, and whether there's kind of other things kind of splitting the difference, example being like comparative negligence cases. So it talks about a number of different situations, for instance, in contracts, when you're looking at whether there's coercion or invalid consent or a lack of information, so that you're entering into a contract, but maybe you didn't have all the information, or maybe there was some level of consent. Again, asking that continuum question, can we be somewhere in that continuum? That's on page 146 when it's talking about contracts continuized. Then looks secondly at good faith purchasers for value continuized on page 147. Again, looking at things like you either require that a good faith purchaser in a radio that's been stolen, somebody good faith purchases it. So what do you do with the radio once you discover that? So the courts can either require the good faith purchaser to return the radio. They bought it in good faith, but they need to give it to the original owner, or they can allow him to keep it. So the argument again, can we do a continuum? Should the law look at perhaps they split the difference of the cost? One person gets it and gives the other one half the value. Is there some in between? Looks at that again in the situation of criminal law defenses on page 148 and 149. And then just talking in general on page 149, the rest of the law continuized, why not treat causal proximity the way we treat spatial proximity as something that comes in degrees, and sets forth examples of that. And then again talks about it in the scenario of personal identity, for example, on page 150, talking about if you move A's brain into B and B's brain into A, who is A and who is B? And then what if you can only move part of the brain? So I don't think we really have the science for that, but it's in theory asking what makes a person, how much of their brain makes them a person, and where is it on that continuum? Where is it on the scale? So it gives some other examples in here about dissenting voices for evidentiary uncertainty on page 151, and talking about if the prosecution's evidence falls short and you demonstrate guilt by 75% probability? Is that enough? What if it's 80%? Like, again, looking at this whole continuum on damages, on responsibility, on negligence, and where we should be at. And then also looks at it, this continuum as to color perception in the scenario of when they were looking at what people see in motion pictures as far as shapes and colors, starting at page 153. So finally, it goes to the conclusion on page 155 about the law has a reputation for splitting hairs. And in fact, the author argues that this is well deserved, that legal doctrines have sharp and hard to justify boundaries. And so he's going to then continue through this section of looking at this. Why is the law either or? Why do we draw these hard and fast lines in the law? Why do we not allow this continuum, this line where we can move from here to here and change either what the criminal liability is or the civil liability in a case? So we'll explore that further in the rest of this unit, and we'll talk about that next week. Thanks.